I'll let Professor Golden take it away with the Q&A panel. By way of introduction, we have with us today Chief Judge Stark. Chief Judge Stark is the Chief Judge of the United States District Court for the District of Delaware. He served as Chief Judge since 2014, and he joined the court in 2010 after being appointed by President Obama. Prior to being an Article III judge, Judge Stark served as a federal magistrate judge on the same court. And Judge Stark has an undergraduate degree and master's degree from University of Delaware and a doctorate from Oxford. His law degree is from Yale. Judge Albright is a judge in the United States District Court for the Western District of Texas. He's formerly a United States magistrate judge of the same court. Judge Albright earned his BA with honors from Trinity University and his JD from Texas Law. He taught trial advocacy at Texas Law for several years as an adjunct. Before becoming a district judge, Judge Albright was a partner in the Austin office of Bracewell, where his practice focused on IP law. He was in private practice at other firms in Austin from 1999 to 2015. Judge Bencivengo is a federal judge for the United States District Court for the Southern District of California. She joined the court in 2012 after a nomination from President Obama. Prior to her nomination, she served as a federal magistrate judge for the U.S. District Court for the Southern District of California, starting in 2005. Her JD is from the University of Michigan, and Judge Bencivengo was the national co-chair of patent litigation and private practice before becoming a magistrate judge. And with us today to moderate the panel is esteemed Professor John Golden. Professor Golden has taught administrative law, contracts, patent law, and writing seminars relating to innovation and IP. Since 2011, he served as faculty director of the Andrew Ben White Center in Law, Science, and Social Policy. His research has primarily focused on issues relating to innovation policy, institutional design, patents, and remedies, which is very apropos for today's discussion. Professor Golden has a PhD in physics from Harvard, a JD from Harvard Law, and an AB in physics and history from Harvard College. Before joining the Texas Law faculty, he clerked for the Honorable Michael Boudin of the First Circuit and then for Associate Justice Stephen Breyer of the Supreme Court. He also worked as an associate in the IP department of Wilmer Cutler, Pickering, Hale, and Dorr. So without further ado, Professor Golden, take it away, and thank you all for joining us again.
Okay, great. Thank you. And thank you to Roy and the student editors of the Texas Intellectual Property Law Journal for organizing a great symposium and helping to get the technology set up. I did a practice session with Roy earlier this week. I will make one correction, however, for the pronunciation of the First Circuit judge's name for whom I clerked, which is it's generally he pronounces it Judge Boudin. And we did hear when I clerked for him various pronunciations by attorneys arguing cases before him. So it did highlight one tip, although I don't think he ever took much offense or concern with it. But one tip might be to learn how to pronounce the judge's name.
I would agree with that.
Before you. The bigger tip for Judge Boudin, who's a tremendous cat lover, however, is not as a practicing attorney before him to start one of your responses by saying, well, there are many ways of skinning that cat. That led to the greatest look of horror on his face that I saw during the year I clerked for him. So anyway. Well, we have a great set of judges here on this panel, and they're district court judges, which I think is very to the point for concerns with remedies and patent damages in particular. The Supreme Court over the past decade and a half has helped emphasize areas where trial court judges in particular have discretion, and remedies has been one of the areas, both with regard to, say, monetary remedies and with regard to injunctions, which are going to be talked about later today, though not so much in this panel, where the Supreme Court has emphasized the trial court's discretion. Okay, so we're going to look at a number of areas where the district court judges have some role to play in determining how arguments are made and even what arguments can go forward. Even before you get to the arguments presented in court, however, there's a question of discovery and required disclosures The Northern District of California, as some of you may know, had rolled out a new set of local patent rules a few years ago in which they made provisions for early damages discovery and disclosures. The thinking being that this is often, at the end of the day, what many cases are about, particularly in an age where you have a lot of litigation brought by non-practicing entities. And therefore, if you could try to, front load some of the work on damages, maybe you could get the parties to resolve their cases earlier without having to litigate them all the way to judgment. So in any event, I'll start with Chief Judge Stark here and get his sense of the potential utility of early damages discovery. Have you ever explored using this with parties? Does it lead potentially, to more problems than it might help solve, in your view?
I think the short answer to all of that is yes, and I'll get to the long answer in a moment. But first, I want to thank Texas Law School for inviting me. I do wish we could all be together in person, though, as I'm sure you all have heard from many people around the country. I'm glad that I wasn't in Texas a couple weeks ago, but I'm sure I would be happy to be there now, and I hope you all are well. And speaking of pronunciation, if I caught what Roy said correctly, I think it's Tipple J that I want to thank also, and those who put the conference together. So thank you for that. On early damages discovery and exchange of contentions and even documents and theories of damages fairly early in a case. As Professor Golden mentioned, the Northern District of California has sort of led the way on this by writing it into their local patent rules, which I understand mean that basically in every case, there is mandatory early exchange of what your damages theories are and the supporting evidence for them. We don't have anything like that here in Delaware, but following colleagues in the Northern District of California, I've experimented, I want to say probably less than a handful of times where I have required similar early exchange of damages related materials very early in a case, before claim construction, maybe even before exchange of infringement and invalidity contentions. And where I've been talked into experimenting with that would be a case in which the parties gave me some reason to hope that perhaps if only the plaintiff understood what the universe of potential recoverable damages were, that could resolve the case because plaintiffs would come to understand early on you could win everything, and at the end of the day, you're just not going to walk away with very much money, so it's not worth it. Or at a minimum, this would shape how the rest of discovery would go and would shape how the rest of the case went. And consistent with Rule 1 of the Federal Rules of Civil Procedure, we could proceed in a more speedy, just, and inexpensive manner if only both sides understood the universe that we were really operating in terms of what was at stake. My sense is, though I don't keep careful records on this, that I'm batting about 50% on the handful of times I've tried it. I think a couple of times it did lead to something very productive, maybe once even to a settlement without me having to do too much beyond order the early exchange. But in at least a couple of other cases, all it seemed from my perspective to lead to was early damages disputes and principally discovery disputes related to damages, and only slowed things down and made them probably ultimately more expensive. And so I've not yet been smart enough to figure out which cases are the right ones to do this in, but I'm open to it.
And judges Bencivengo or Albright?
I would agree with Len's analysis. First of all, I also want to thank you for inviting me. It's always a pleasure to participate on any panel with Chief Judge Stark, and Alan and I go way back, and he'll just be, well, I love Alan from the old days when we were partners together at Gray Carey. But anyway, it's a case by case kind of thing, and sometimes it's much more focused at trying to wrangle discovery, as well as getting a sense of the number that you might ultimately be going for. Hypothetically, you've got someone who's got a patent on some component part, say for a GPS system in a car, and they've sued a bunch of car companies. And so at the case management conference, I'm going to say, look, the price of the car is not going to be the royalty base, right? Because that wouldn't make any sense. So I need for you to kind of be able to articulate, where are we going with the base, just for starter points. Or if the patent's been litigated a lot, let's just get those licenses out on the table so that we're dealing with a known quantity here. On a small case, or a case where the defendant comes in and says, we haven't even sold this yet, we've offered it for sale, there's no money here, then yeah, maybe you want to talk about that right up front. Or the distinction, if you're going for lost profits, on what basis is your lost profits claim? These are more at theory levels than filling in the numbers, but those can be very useful in directing discovery.
Right, great. And Judge Albright, do you have? Yeah.
Well, let me echo my gratitude for being invited here. It's I thought this morning it's like being a minor league pitcher and getting invited to pitch with the New York Yankees with these two other judges. So I'm appreciative that I get to sit and talk with them. I'll try to make this too long, but when I got on the bench, I put together a committee, and the goal of the committee was to come up with a set of rules that both sides were unhappy with, which I thought would be the fairest. So I mean, it's defense and plaintiffs counsel, big plaintiffs, small plaintiffs, everything. And what we all kind of negotiated out was there was no discovery in my court until the Markman. And the trade-off there is, in part, is that when I handle a Markman, I rule on the Markman at that time and discovery opens up. Now, to deal with this issue, I didn't want lawyers coming to me saying, Judge, we'd like to exchange information, but discovery stayed. And so we don't want to violate your stay order by exchanging information. And so I made it clear that that was an exception to the stay. But to Len's point, as soon as I did that, it's because everything's binary. As soon as one side says, no, you're really, I'm trying to use the right word here, you're really negatively impacting us by this decision, because especially the defense were like, gosh, we've got to get all of this information. It went on. And so what I've tried to make clear in my rules is I see, I think all three of us do, the early disclosure of information is an effort to benefit everyone to know whether the juice is worth the squeeze. But so in my court, at least, though, that means it's entirely voluntary. So if the defendant, I'll just name a name, if Walmart, I don't think of any cases with Walmart, but if Walmart doesn't have any interest in trying to get the case resolved early and they say, we don't want to give you this information, I'm fine with that.
Ooh, you froze.
Is he there?
Okay. I think he froze.
Uh-oh.
Walmart pulled your plug.
Yes, I know, exactly. Power Walmart coming in. Well, hopefully it'll resume at some point, but we'll take that as a conclusion for his remarks on.
Professor, can I just add, because I think it's interesting that all three of us are former magistrate judges. Right. On our court, the magistrate judges lead our ADR, our alternative dispute resolution, mediations and the like. And we have empowered them, regardless of what's going on with discovery as a formal matter with the district judge. We've empowered them to require, as part of the mediation, the exchange of early damages related discovery if they think it will be beneficial to the process of trying to resolve the case. And I think we've had some success from that. That's a less formal process, but I think it has helped promote settlement.
Right, great. So we'll see. Hopefully we can get Judge Albright back, but okay. There you go.
John's back.
So,
He'll be back.
well, we'll start with the next question, which was going to be directed to Judge Bencivengo first. So we have the timing of discovery. Then on the back end, another timing issue or concern often is the time at trial devoted to damages issues. In particular, someone obviously when it's not a bifurcated trial with damages set off for a later part of the case. And here, I think there's often a concern that in part because the attorneys involved often feel pressure to focus on the liability side, that damages, after a lot of development with experts, sometimes expensive discovery, getting all this financial information, there's a concern that damages then gets relatively short shrift. So I guess a question here is what can or should trial judges do to try to help encourage parties to give the damages issues their due, or is this something that really just should be left up to the individual attorney decisions?
I think you'd be in a rare situation now in any federal court on a civil case if you're not put on a clock to run your case. And it may be not an hour by hour, but you've got this many days, so this for your case. So people go in with presumably an agenda saying, I've got 20 hours or 30 hours or 10 hours to put my case on, and you need to budget that time. And I have been at seminars with damages experts where they said, after all the work we've done and recognizing that filling in that blank with the dollars is really what this is all about at the end of the day, they left me 15 minutes to put my whole presentation on. And, then they feel rushed and it doesn't really get to be completely, understood by the jury. And yes, obviously, if you can't prove infringement or if you don't get past an invalidity challenge, you're not going to get to damages. But there's a thought process there in organizing your case where you can't leave this tail of the dog just sort of hanging off and not have time to get to it. So as a judge, not my responsibility. I let you try your case. I tell you how much time you have. I give you a daily summary of how much time you have left. People need to plan for that. What I would recommend is, while you may have to do like the whole Georgia Pacific 13-factor analysis for your expert's report, I don't really think the expert needs to go through and tick off every one of those on a whiteboard for the jury. Most of it's just going to go right by them anyway. There's certainly ways to compress those into categories to talk about, these are the things I thought about in reaching my decision. But you want to get to a number that people can get their head around and think it's supported by facts and opinion, the opinion is supported without, I think, marching through all of that detail of Georgia Pacific. But it is interesting that more than one expert has, sort of bemoaned the fact that they just don't get enough time to do their deal at the end of the case, which is not good.
So, Chief Judge Stark, what was your experience with this in terms of the time devoted to damage at a trial? Does this seem like a common problem where it's not given as much time as it deserves?
Well, my experience has been very similar to what you already heard. Whether it's a problem, I guess I would probably leave to others, but empirically, I think it's true that the amount of time devoted to damages in front of the jury tends to be small and sometimes surprisingly small. A typical 2-week patent jury trial here in our district means probably 20 to at most 25 hours per side. And we do pretty tightly time all of those trials. And it would be unusual if more than 1 hour, maybe 2 at most per side, was devoted to damages. And that includes what they say about it in opening and in closing, as well as in their direct examination of their expert and their cross of the other side's expert. the tail on the dog is very much the metaphor that comes to mind as to how I see it handled. And this includes big cases and small cases. I presided over a case, Adenix versus Gilead, which returned a verdict, a jury returned a verdict of $2.54 billion that was later vacated. And the case has worked its way through the Court of Appeals and the Supreme Court and ended up with zero damages in the end for unrelated issues. But that case came in part to be known for being such a large damages verdict. It may have been the largest damages verdict a U.S. jury had returned in a patent case. But if you go back and look at how much of the 2 weeks was spent on damages, I think you'd be surprised. It was on the order of consistent with what I set out. Maybe a half a day altogether out of an 8, 9, 10-day trial was devoted to that. And that's partly because the other issues are very complex as well. Infringement and invalidity in a patent case are not easy issues, but it's also partly because it almost always is left to the end, right? They almost always do want to talk about the technology first, and then they sometimes run out of time. And so it can get much less attention than you would expect.
Right. And Judge Albright?
Yeah, I don't have a lot to add to that, of course. So I'll try and add a couple things that are helpful to those who are listening. One is, of course, the problem with selling yourself short on time on the damages testimonies. That's, if you get a verdict, if you're planning to get a verdict, you got to have some stuff in the record to support it. And, so that's very important. But Cathy was right that I don't think there's a case being tried now that doesn't have time limits. And my observation, which is hopefully helpful but not directly on point, is the reason people run out of time, from what I've observed, and this is after only 2.5 years compared to the collective of time of the other judges, is attorneys seem to be incapable of stopping their examinations. So, and I don't do it for them because they're on a clock. So, but it will be direct, cross, redirect, recross, redirect, recross. It's almost like they have this feeling they've got to have the last word, or they've got to make some point. Meanwhile, it may only take 5 minutes or 8 minutes or 12 minutes or 15 minutes on that third or fourth round, but you've just eaten up 15 or 20 minutes of your time for your damages expert. So, my advice to everyone who's listening is to protect the damages expert. And that's what I used to do a lot of in patent cases. Someone needs to be a hall monitor with a lot of gravitas who can grab someone and say, you're not asking anymore. You're done. You're sitting down because we need that 15 minutes down the road. And let me add, as we all know, no one thinks anyone else's examination is as important as theirs. And so it can't be you. You cannot self-police. You have to have someone who will say, don't stand back up.
Oh, that's great as a tip. I can imagine when I was in practice, I was mainly, just as someone not in the litigation department, the IP department. So I wasn't involved in trying to get my time to argue in court, but I do know the litigators would prize that opportunity. And so
sure.
Imagine it's very difficult to pry them away from that.
I would just add that the value of that redirect, recross is, unless something blew open that you had to get at, you're just repeating stuff. And the biggest complaints you hear from juries are, we got it the first time, we really got it the second time, it was insulting the third time they covered the same thing. And when you get up and say, I just have one more question and ask 5, they start to notice that, and it becomes a joke. It's like, oh, here he comes with a one more question, but there's going to be 5. And yeah, being sort of, I believe the term is judicious, about, do you really need to get up and do this? Do you need to cross-examine everybody? Probably not. So, don't waste your time.
I'm convinced, and this won't ever happen. I can guarantee you I will never go back to practicing law. I have nightmares where I've gone back to practicing law and wake up. But if I were forced to go back to practicing law, in every trial I had, if I were doing an examination, whenever I was done, I would look up and say, Judge, I have 15 more minutes, but I'm going to give that time back to the jury. And I would do it every time. And you'd have 7 grateful jurors in my court.
Right. Yeah. Chief Judge Stark, do you have a comment?
No, I was just saying giving back time is welcome, not just by jurors, but by judges too.
It's true too.
Yeah, I was going to say when I clerked at the First Circuit, it was notable that, it was kind of interesting. It was often, you appreciated when attorneys would just close their case. I think I'm not sure it was ever done by anybody other than a U.S. attorney or assistant U.S. attorney, basically saying they didn't feel they needed their rebuttal time to use it. So, okay. So now I'll turn for the next question first to Judge Albright, and here we'll turn to something, as you expect, more intermediate between basically the timing of damages discovery and the time to damages at trial. But here the issue of Daubert gatekeeping, which the Federal Circuit, again, through a series of cases over the last decade or so, has re-emphasized with regard to patent damages as a way potentially for judges to help ensure in some ways or certainly police the quality of damages judgments. And they've gone through many of the sort of factors or things that Dr. Hugo talked about in the last session as things that need to be policed, whether things are comparable licenses, the models or economic models or game theoretical approaches being used by experts. And so, I guess a question for you and then ultimately the other judges is, to what extent do you think Daubert gatekeeping is a very useful tool to try to help ensure quality judgments, and how aggressively do you try to deploy it to try to police what goes to the jury, as opposed to viewing things as a question of weight rather than a question of admissibility?
Well, I'll tell you, I'm probably like the other two are schizophrenic on that, and here's what I mean. Obviously, we all take that role seriously. I think I have in more than in the case I just finished trying last week, I had granted a Daubert on one of the experts in the prior trial. I granted it Daubert, so I get that, and I'll get to why in a second. The reason I say I'm schizophrenic is I don't think I'm alone in saying that I get a Daubert about almost everybody. Either I get a Daubert for every expert, or I get a Daubert about some opinion every expert has given. And that's why, and to me, that dilutes the power of the Daubert, and it dilutes my ability to really do a good job when you have 16, when you have 8 experts and you have 11 Daubert motions. It dilutes it. What I see my role as, I kind of view less from the Fed Circuit perspective than I do up from the trial lawyer perspective. And what I mean by that is you can't, let's go back to like the 25% rule that we had several years ago. If a witness is saying, I'm going to use the 25% rule, you can't cross-examine effectively that witness at trial on whether that's the right thing to do. It's just nuh-uh, nuh-uh. That's what he did, and whether it's the right methodology is something that I have to do as the gatekeeper. Now, if I make the decision, the 25% rule is acceptable, and obviously the circuit decided it wasn't, and I get that. But if you decide that the methodology is acceptable, then it's up to the lawyers, in my opinion, to determine whether or not there's sufficient evidence to support it. Did they, put on the right technical information to show the value of the patented feature to the product? Go down the list, and then did the expert apply it correctly? Did he get the right? Did he get the right number of widgets? Did he get the right myriad of benefits there were to the widgets? What did he do? To me, is often cross-examine material. And you can also put your own witness on to say the opposite. But I'm a big believer that if it's something that my rule of thumb, which I can't articulate very well, is can you cross-examine someone on it, or is it the expert was either right to do it that way or they weren't? And that's where I see my gatekeeping function. I don't think any of the three of us in a patent case has ever said, oh, that person, it wasn't a PhD or it wasn't someone competent to give an opinion in that area. Lawyers are pretty good about getting qualified people. But I am a very activist judge on Dalbert. We read them carefully, and like I said, I've granted several.
Great.
I'll go with, and I think we all agree, overused. Way too many are filed. Challenging the value of the opinion as opposed to the basis of it, that it's just improper. It's not usually the person's credentials. It's rarely the person. I mean, occasionally you might get somebody who they say this person isn't a person of ordinary skill or doesn't have the credentials to talk about a person of ordinary skill in the art, but that's really rare. And so most of them, yeah, I look at it from the same point of view that Judge Albright said. It's like, is this just cross-examination? This is going to be great cross-examination. Go for it. As opposed to, I'm going to exclude it. But I have on occasion, and it's been somewhat rare, but I have excluded people who have come in with stuff that's just contrary to the law. Or has no foundation in the law, and there's no methodology that suggests this is appropriate. And under 403, it would be so confusing and prejudicial for the jury to even hear this when there's nothing in the instructions that are ever going to support this theory. It's like, it's out. It gets complicated if that person's theory becomes part of someone else's opinion, because then you're kind of line iteming that person's opinion, going, oh, well, you relied on, Professor X or Dr. X, and that's out. So you can keep your opinion to the extent you can't reference that, and you can support it by everything else that's in there. But I kind of look at it the same way you get summary judgments where it's like, my facts are better than their facts. That's not my job. That's the jury's job to decide whose facts are better. I don't get to weigh that evidence. And a lot of Dalberts are, our expert's opinion's more solid and believable than their expert's opinion. Well, that's not gatekeeping. That's jury decision. So it's become overused and frustrating.
I just would like the chance to echo everything that has been said by my two colleagues. In a typical patent case, there are multiple, more than a handful of experts on both sides, and typically they all get a Dalbert against them. Sometimes it's multiple Dalberts because, they've expressed multiple opinions, and you're dealing with very busy judges. There's only so much time that you can give to each of those motions, and it's generally much more effective to pick and choose your best targets. Just trying to kind of pre-try the case and tell me that there's not any good answers to my terrific cross-examination, that educating me on that really doesn't get you anywhere, and it certainly isn't going to meet the Dalbert standard. And yet that's a lot of what we see. I too have granted some for sure, and I'm sure that my calls for hoping for fewer Dalbert motions is probably going to fall on faint ears, in part because you might win them, and occasionally you win them and you do fatally wound the other side because they just don't have time to recover. But it's few and far between, and with damages, it tends to only be where, as was mentioned by my colleagues, If there's clear law on a point of damages and the expert, for whatever reason, looks as if he or she has a model in this case that is inconsistent with, that is in contradiction to that clear point of law, that's where, I think the law directs us to not let that testimony go to the jury. But that doesn't happen very often.
Okay, great. So I do want to note for the audience's benefit that as in the prior session, if you want to register questions through the Q&A function, I'll be looking to see that. I know we have enough to talk about, based on the time we've already used and the sort of questions prepared questions I have left to use up the time, but I will be interested if audience members want to interject their own questions. We can either work those in at the end, or potentially if they relate to things being said, we could try to work them into the discussion just as it flows. Well, the next issue I thought I would talk about is here in some ways trying to regulate the jury's output or what you get from the jury in terms of output, and also potentially to help guide jury decision making through special verdict forms. This is sometimes thought to be helpful in giving jury guidance, what might be a complicated damages calculation or a damages calculation that's going to involve various different parts with different patents or at issue. But on the other hand, you can worry that whenever you add kind of more work, more steps for the jury to go through, it could add to their sort of cognitive burden, something else they have to try to understand, and then B, could lead to confusion if they don't totally understand the form and they have parts of it that are filled out inconsistently, even if they really did reason their way correctly to the final number they wanted. So question here for the judges, and we'll start here again with Chief Judge Stark, is what are your views relative to the utility of special verdict forms? When do they seem to be useful? How can one try to avoid some of the problems that can result when a jury potentially could end up filling them out inconsistently or in a way that seems ambiguous?
Well, these are really good questions, and this, in my mind, is an important topic and completely overlooked, even in most trials. So, at the risk of boring the audience, because I'm thinking they're probably thinking, who wants to hear a discussion about special verdict forms and damages and patent cases? This is a really important topic, and it tends, in the typical case, at least in front of me, we might get a draft, we might get competing proposed verdict forms right before trial, and then they sort of get put aside while we focus on trying the case. And then the night before we're ready to instruct the jury, we dig them out and we see all the disputes and we talk to the lawyers, and they send usually an extremely well-prepared attorney, but maybe one I haven't seen before, in to talk about what exactly should the verdict sheet look like. And it's not always clear that the whole team has really thought this through, and yet a lot can turn on it for the reasons that you just set out. So I just want to applaud all of us for putting some attention on it. In terms of what are the issues that come up, I mean, conceptually, it's a challenge, because you ultimately want to give the jury something that doesn't confuse them, that doesn't push them towards one side or the other, right? If it's so complicated that they can't figure it out, well, that's going to unfairly help the party that doesn't have the burden of proof, presumably. Whereas if it is too easy or implies an answer, then that's not fair either. And you're trying to translate the complexity of what was presented on an evidentiary basis to an understandable answer that you can then enter judgment on. And ultimately, in almost all these cases, we get the post-trial motions to review the verdict. And we have to, think about what kind of assumptions are we willing to make about what the jury did if we don't ask them to show us all of their work. But if we ask them to show all of their work, what happens if we do find a mistake along the way or an inconsistency along the way? Can we uphold their ultimate answer, or do we have to start all over again? And even if we are not persuaded to start all over again, of course, most of these cases, especially if they have a large verdict, end up being reviewed by the Court of Appeals. And, they're going to look very closely at the verdict sheet and how it maps onto what evidence was presented and what arguments were made. And so all of this factors in a very real way. And I'm not sure that it gets enough thought from the typical trial team. And that makes our job very challenging in balancing all of these competing interests.
Great. Judge Bencivengo?
Yeah, I agree with that. Having drafted them as an attorney and then reviewed them as a judge, they don't get thought through. Now, part of the problem, I think, from the trial team perspective is, the case, you kind of know where you want this form to go, but that may not necessarily be clear to the jury. So damages aside, even with infringement and invalidity, where you can end up with inconsistencies in a verdict form where it's really laid out and you want specific answers. One of my colleagues tried a case 3 times because they the jury just couldn't get the boxes right. And the first time it was because he dismissed, they got the verdict, they read it, they dismissed the jury, and then the defendants went, oh, by the way, this is inconsistent. So lesson learned there was, as a judge, if there's an inconsistency, tell me, because I could always send the jury back and have them try and unravel what they did. But once they're excused, then you're in a new trial. But on a damages point of view, to some extent, getting more is better because it as Len said, show your work. If you've got multiple patents with different products and different royalty rates, and let's say one of them is found infringed and not infringed, and you may be able to scrap together something at the end of the day from the verdict form that's recoverable and enforceable. But if you just have, put a number in here, X, and there's 3 patents and different products and different rates, and you have no idea what they adopted to get to that number, and there's a really good chance that number is not going to match either expert's number, because somewhere along the line they compromised on something. And so you can't just go, oh, okay, they adopted this expert's theory because the number matches what he testified or she testified to. Having that information is helpful, but it has to be thought through and prepared and obviously agreed to. I mean, there may be objections that you preserve for the record, but be nice if you can get both sides to agree. Here's the information we want to cull from this jury when they go into the jury room. And doing it the night before is not going to work.
And Judge Albright?
Yeah, I am burdened by the fact that I'm actually pretty lazy and want to put off any dispute I can. But what I've learned on this side is it's much better to go ahead and use the intellectual elbow grease to get these things on or in the charge if you can. Most of the lawyers know what the fight is over, and then you come up with the language for it, because the last thing you want, for example, in the case I just finished, is to have something where the parties are arguing over what the jury intended in their verdict. And so I am probably moving in the direction of a more is better. In the last verdict, for example, in the last verdict form we did, we isolated each patent. We isolated each patent claim for both infringement and invalidity. We asked questions about the scope of the what scope the damages amount covered. I am becoming a bigger and bigger believer that getting the jury to answer things is prophylactic for me. because then we'll have it done, and I won't be overwhelmed with having to try and do something post trial. So and then of course the other benefit is I don't know how the other two judges do it, and I only do it because the judge I clerk for did it this way, but I read the charge first and then the lawyers argue. And so the lawyers are certainly able to, they have the verdict form. They can say, this is what the judge told you, or this is what's in the verdict form. And, you need to answer yes or no. And you can make that part of your jury charge, your closing argument. So I am for getting as much information from the jury as possible.
And I just want to go back for a quick second, because two of the areas that you run into real problems that might ended up having been vague or ambiguous to a jury with regard to the number is, did it include prejudgment interest or didn't it? Is it a flat fee that they've now licensed the patent basically going forward for this value, or is it just past damages for what they did? So those kind of things that become up in post-trial arguments are really significant in determining when they do fill in a number, what is that number including? And interest is a big one that people fight about later. And the other, well, anyway, I'll let go. But we talked about it earlier, and I'll throw it out there because these two guys have had these big billion-dollar cases that as a lawyer, because I pre-instruct before closing. So if you're going to take that verdict form and help the jury fill it out during your closing argument, and you're talking about numbers in hundreds of millions or even billions, you might want to tell them, don't put zeros, just write the word, because a misplaced comma could be really significant.
And I'll just say as well, I also pre-instruct. So I will read the detailed instructions to the jury before they hear the lawyer's closing argument. And that does, I think most jurors have told me that they appreciate that. It helps them better understand where the lawyers are trying to maybe sway them in a way that perhaps is not consistent with my instructions.
I saw a question in the chat about using the special written findings as opposed to verdict form. I actually haven't done that in a patent case. I just did that in a excessive force case where in a 1983 case where the defendants wanted the jury to make all the special findings about whether or not this police officer had used excessive force and in what aspects. And fortunately, the jury, checked a very consistent fact finding that matched their verdict. So it was really useful to have that. And that can be helpful because it does give you the underlying facts that later, when you're arguing at the appellate level, what are their facts that supported this? What the jury relied on. But it still requires preparation. It's not the night before kind of deal.
Right. So, yeah. So this, again, we did get a question on this sort of use of 49A1, which is characterized as the formal technical special verdict versus 49B1, where it's a verdict with answers to written questions. And that's what Judge Bencivengo was talking about.
Hasn't come up yet for me.
Right. Okay. Okay. Well, one thing that was just mentioned here, which is sort of natural, we're talking about verdict forms, is talking about instructions that might accompany those forms. So that's the next thing I did want to focus some attention on, as a question of jury instructions. Here, there have been concerns, perhaps particularly, say, with calculation of a reasonable royalty, where there's this list of over a dozen Georgia Pacific factors that is often cited. There's some concern if those are incorporated, say, in the jury instructions, that sort of almost automatically is creating an excessive cognitive burden for the jurors, could lead to confusion, distraction. And so there have been, questions raised as to whether judges or parties should really work to have a kind of more streamlined set of jury instructions related to damages that are more tailored to the particular case and help focus the jury's attention. So with this, I'll start with Judge Albright in terms of, what's your approach to the sort of development and say the reading presentation of your own presentation of jury instructions?
Well, I'll tell you, I was doing one of these 6 months ago, and a very fine judge from California told me that he didn't allow PowerPoints during his Markman hearings. And I told him, are you kidding? I thought there was a constitutional right to use PowerPoints. So if either of these two judges tell me I don't have to read just about everything that you talked about, I will be the happiest judge on the planet. But for example, in this past week, where two very fine, well, lots of lawyers, but from two very fine firms, including one that you were with, we all agreed that the safest route to go down was to read all of the Georgia Pacific factors, because they've been discussed, and we thought it was important to do that. I think it took me a full hour to read the jury charge in our case. I think there is a lot of repetition, and I know my two colleagues agree with that, but most of it is unavoidable, because as you go through the different parts of the jury charge, you have to say things over again. I don't see any, I don't really see any way of making the jury charge any less cumbersome than it is. It's the area where you have a fresh set of lawyers coming in to do whatever they can to make sure there's error in what I'm doing. And so it's which is fine, but it's like the six blind men trying to figure out what an elephant is by touching each part of it. I think I foresee always having a 45-page jury charge going forward in a patent case, because there's just so much you have to discuss. For example, if you add validity, you've got a brand new burden of proof, and you've got all this stuff. So, and with damages, I think you're going to have to. I think you have to read the Georgia Pacific factors, and if it's a reasonable royalty, and I think you have to explain all of what that is.
Almost every patent jury trial I've had, the instructions are at least an hour. I want to say an hour and a half is not that uncommon, and you are trying to be ultimately helpful to the jury, but the law requires you to instruct them on certain things. Each circuit has, I think, some standard instructions that you have to give basically in every civil trial. I think my colleagues do this as well, but I will give a hard copy of the instructions to each of the jurors, and so they can follow along with themselves. And they do, in my experience, they tell me afterwards they really rely on the instructions. They have them in front of them during their deliberations, and ultimately it often turns out only a few pages turn out to be really crucial to what they're trying to resolve. But we don't know, of course, what those few pages are, so we have to instruct them on everything. And the other key for me, and Alan sort of suggested this too, is trying to get the parties to agree. All else being equal, if they agree that I should read all the Georgia Pacific factors, even though maybe I think I should only highlight two, if they've agreed, I'm going to spend the 5 or 6 minutes and I'm going to read the whole thing.
Right.
Yeah, it's interesting to me because in patent cases, jurors get more instruction than they kind of do. And if you do the federal judicial centers, this is a patent case, in jury assembly, they've watched this video. And so they've kind of heard about patents and how you get patents and validity issues. And then you pre-instruct and you do a little bit of the, this is a patent case and blah, blah, blah. It's more than just the standard burdens of proof. And here's, how you're going to weigh credibility. So now you're at the end. And we all do this, give them the set of instructions to read along, which I think is critical. I was in an in of court group and we interviewed former jurors, and one juror was just that by giving one set of instructions into the jury room, you give somebody a huge power shift, because they hold those instructions, and if there's a question, they're like the monitor of the instruction. And it really can shift the balance in a jury room. So as litigators, you should really be thinking, you want every juror to go in there and have the rules of the game, so that they're all participating in that analysis. And so it does help for them if they can read, when you're just talking to people for an hour reading something, how boring is that? So if they're reading along, it kind of breaks it up a little bit. But again, by pre-instructing before closing, I think you get that whole sort of, this stuff is extraneous, out of the way, because the litigators can then go back and say, these are the instructions. These are the, I mean, yes, you have to consider all of them. They're all important, but here's the one that's going to give you the direction on this issue. And it helps narrow it down to, like, Judge Stark said, that handful of instructions that may end up being debated in the jury room, they'll get some focus. There's an awful lot of guidance out there for patent instructions that we get from the Federal Circuit, from different groups, from the Federal Bar, Federal Circuit Bar Association, and they're all helpful. And I think there's a lot of uniformity in sort of the standard instructions. So when people want to write their own, that you got to be careful, because then you're kind of going off the rails a little bit.
Okay, great. Well, we have a couple minutes left. So I do want to, we have one last issue, which we may not get too far in it, but I know another issue related to normal patent damages is if you have a case after eBay where an injunction is denied, there could be a question of whether there's an ongoing royalty. That could be, there might not be if your damages award was meant to sort of account for a license for all time. But I guess, Judge Bencivengo, I mean, what should parties think about if there's the possibility they're going to be arguing over an ongoing royalty at the end of the day? What helps put the trial court judge in a sort of the best possible position to try to rule on that?
Yeah, it became kind of a high point, interesting question after eBay, when people came back and said, okay, I'm not getting an injunction. They still want to practice the patent. You decide, you negotiate a license for us. And it's like, really, is that my job? Because if I issue an order saying, here's what you're going to pay, and you get in a dispute, are you going to come back to me as a contempt of court because you violated my order and do I have to negotiate your license in perpetuity? Because that's really not my job. And there was a rather optimistic, but I think kind of like really opinion from Judge Rader at the time, saying, well, get the parties to negotiate the ongoing license. It's like, because they've totally agreed to everything up to this point. So that's going to happen. And I tried to punt on the issue and send the case up to the Federal Circuit for review of the underlying decisions before I decided an ongoing royalty. And they sent it back and said, no, you got to do this first. And you get in all these disputes about, well, if the hypothetical negotiation assumes an infringed valid patent, then why is that any different afterward? Why is the rate that the jury gave going to be any different than, because it now is an infringed valid patent, and that was the underlying assumption in the first place. And is it really willful because I didn't give an injunction? I said, yes, in the public interest or for whatever reason, you should be allowed to continue to make this product. You just have to pay for it. So there's so many moving parts. And I think having your expert think about that, even if it doesn't get presented to the jury, but is sort of built into an analysis you're going to present to the judge later, is important, because otherwise we're going to hold a whole new hearing and whatever on this whole issue of ongoing royalties. And I think you could still, as judges, make a fundamental argument that's like, I don't even have jurisdiction to do this. This is infringement that hasn't happened yet. This is an advisory opinion I'm giving you as to what you would have to pay if you decided to keep making this product next week. And that, we don't do advisory opinions. So, go infringe it and find out what happens if you can't figure out a royalty rate and you decide to keep making it. So it's the end of the program, and I just throw that out there.
Okay. Well, great. We have come to the end of our time. I'm sure we could continue talking, but I it was great to have a chance to talk to all three of you. Thanks for coming and joining this conference, and have a good remainder of your Fridays. Thank you.
Thanks. Thank you, everyone.
Thank you.
And thank you, Professor.
Thank you,
Okay.
Professor.
Yeah, thanks for.
Hi, everyone. We are going to take a 5-minute break before our next panel begins, just so that people can get up and stretch their legs real quick. And over the break, I can assist you, Professor Greenberg, in getting any slides up you might have just while we wait there.
All right, fantastic. I think we are